What's up, y'all? It's your girl Jay Renee with Prison Riot Radio. I hope that you're doing well. This evening, we have someone that's going to talk to us about some different Tennessee laws that we might not know and talk about some different things that they've seen when it comes to the Tennessee judicial system and its corrupt practices. We've heard a few things about Tennessee over the last few months, maybe at the top of the year, but we're going to dive a little deeper into some of the things that have gone on in Tennessee. So give a listen. If you're able to help anything, any of the cases that you hear, please let us know.
All right.
All right, how you doing?
I'm good. How are you doing today?
Doing pretty well. I want to just move on out the way and give you an opportunity to go ahead and jump right in there. Thank you for coming and sharing your expertise with us.
Well, no problem. First of all, I guess you can just call me the Patriot. Well, just call myself the Patriot. I like to remain anonymous due to the fact of the things in which I'm sharing to the public for their review. Okay, I guess to start off with is the reason why individuals, when they get found guilty in criminal courts, the majority of the time is because either the state withheld evidence that those who were innocent and wrongfully accused, and 10 or 12 years later they find it, or they do some kind of improper procedure act, like they deny witnesses, deny evidence to be given, it, whether it's exculpatory or not, because all they want to do is procure a conviction. They don't want to seek true justice, which is the truth, and they try to lie saying they are seeking justice, but they're really not. So when it comes to railroading individuals, the reason why you'll hear some attorneys say in Tennessee that the Tennessee courts are a joke and that the only courts that normally uphold people's rights is the federal court is because of something that people need to know about. Now, it is from the United States of America Congressional Record, Proceedings and Debates of a 90th Congress, First Session, Volume 113, Part 12. It was done in June the 12th of 1967 to June the 20th of 1967. And it says pretty much between pages 15309 to 16558. And pretty much the southern states struck down the 14th Amendment saying that we will not follow the rights of the people of the slaves to be treated equally, nor anybody be treated equally, because we were prisoners of war basically, and we'll never follow it. And the Supreme Court back in the day actually said the same thing in so many pretenses in a case from what I've read in this congressional act. So when they sit there and talk about it, they're saying that they're just sick and tired of it. They're not going to listen to it, and they'll just, whenever it's the federal district, it's the federal district. And it's what gives the states the right to basically railroad individuals, because they're clearly saying in the states of Tennessee, Kentucky, North Carolina, Louisiana, South Carolina, it just keeps going on, all the Confederate states said that since they're prisoners of war, they do not have to listen to the Northern armies. So we're going back into the Civil War now, and this is why we're still having the problems today in today's society here in Tennessee and these corrupt laws. Now, for instance, the United States come out with a case called Strickland versus Washington. Okay? So when you review on Strickland versus Washington, Strickland comes up with something called the preponderance of evidence, right? But people try to argue preponderance is different from clear and convincing because Tennessee came out with a statute called clear and convincing evidence must be shown for counsel to be ineffective. But it wasn't the preponderance ruling in Strickland that nobody's never argued. It was the fact that the result of the proceeding can be rendered unreliable and hence the proceeding itself unfair, even if the errors of counsel cannot be shown by preponderance of the evidence to have determined the outcome. And none of the Tennessee courts, criminal courts and post-conviction seem to want to realize this. They always say counsel's strategic decision and it shoots down the preponderance or any kind of evidence or any kind of clear and convincing. They want just to deny everything. Some cases, the judges, I'm not lying to you, I've seen the records, clearly say that, oh, counsel was ineffective, but I'm denying the relief. So how can counsel be ineffective if they're denying relief? Let's see, there's it's like they just totally neglect Shannon Ramirez's new ruling in the federal court. That Shannon Ramirez come back saying in that case in the federal court that inmates, or should I say the defendants who were found guilty or something like that, have to be the one to provide the record. Now, how can the inmate provide the record if the counsel says, oh, I didn't get the record because I didn't think it was the best interest, and then the post-conviction court say, oh, we're going to side with counsel because it was a strategic decision. You see where I'm going with this? It violates due process. Now, when it comes to other statutes as well. They're creating statutes, once again, that violate the constitutional provisional rights of due process. So, in, like, say, for instance, Tennessee Code annotated 375107, Section C, Section 7. If you are accused of any kind of crime against someone under the age of 18, it says you cannot obtain the evidence, denial of evidence. So why are they hiding the evidence? Could it be maybe the person's innocent and they just want to prosecute? I've did some research down that rabbit hole, and sure enough, I want to say about 50-60% of people are innocent on the he said, she said cases. So when Tennessee come out with the statutes for clear and convincing under 403210F, it actually violated the principles of Strickland versus Washington. And when it comes to such and all these things, any law or ruling that contradicts the Supreme law is illogical pursuant to Mobley versus Madison. And because it was quoted in Strickland versus Washington under 466 U.S. 694, it says the rights are basically under U.S. versus Johnson, quoted in Strickland, that clearly said the appropriate standard of prejudice should be somewhat lower. So that clearly shows lower than clear and convincing. And all they want to do is deny people relief to keep their political gain in their careers. Thus, if you look up the true statutes of domestic terrorism, which I'm going to go there, it says to coerce by threat or violence. Now, I don't know about any of y'all, but threatening someone with a life sentence to take a plea is coercion. And the threat of violence is actually what? Throwing them in prison, an act of suffering. So clearly they're breaking their own statutes for domestic terrorism, in which they say no one's immune under the Terrorism Prevention Act of 2002 in Tennessee. So why do this state think that DAs and all of them are immune? It's just crazy on how they do things down here. Like, why don't they adhere to Article 11, Section 16 of their own Constitution in Tennessee, the Bill of Rights are to remain invalid? How can one's Bill of Rights remain invalid? They're violating them all the time by creating statutes that go against the U.S. Constitution. But we all know a person who is accused of any crime has a right to provide every available defense and has a right to obtain evidence from the prosecution that's within their possession. If that's the case, why did they sit there and say, oh, you can't obtain the evidence in 375107 in a statute they created? Because all they want to do is create statutes in violation of Article 6, Section 2 of the United States Constitution, which states that it's the supreme law of the land, our Bill of Rights, first 10 amendments, in which I also want to bring to the light real quick. First 10 amendments reflect something that people need to know, that, they want to try to say ignorance of law is no excuse, but I want to sit there and say, how is it no excuse if you don't teach it in elementary schools or you don't teach it in high school and stuff? Because if you pull up 42 U.S.C., which is United States Code, 1981, it's going to shock a lot of people, and you're going to see why 1983 was created, 42 U.S.C. 1983, the Civil Rights Act for the suits under the 14th Amendment, because 42 U.S.C. 1981 was the equal protection of laws for rights, but it clearly says white men only. Why does the Constitution say such of a thing? And why does Tennessee follow that instead of the 14th Amendment that was ratified? Why do they say they want to deny to follow the 14th Amendment in that Congressional Record Act? I mean, it's freedom of public record. I mean, anybody can pull it up if they look into it. It's United States Government Printing Office in Washington, D.C. 1967 was the year. So I believe this is the true meaning of why a lot of brothers and sisters in Tennessee are being wrongfully incarcerated because of the color of their race and skin. It's because of these evil things in which these people are doing, in which the truth is now being let out through me. And that's why I like to remain anonymous. All they're doing is creating laws. They're not following laws. They're not following the precepts. They think the person's too ignorant to be able to file a suit, and then their constituents want to sit there and keep the person in prison instead of doing their job and setting them free for justice. Now, I don't know about any of y'all, but that kind of sounds like treason to me.